Leasehold interest. Okay. A lease is a contract. So when you enter into a lease, we're going to talk about some contract law, things like that. But the essential elements of the lease, you need to have a description of the premises. Last night we talked about legal descriptions, but a description of the premises for a lease is typically just the street address or the unit number. However, if you're leasing an entire complex, you're going to get a legal description because if you have the land as well, you're going to have a legal description. So if the entire conveyed premises are being leased, legal description in the deed is satisfactory. If something less than all the premises is being leased, lease should state clearly and exactly what it is to be leased. So my retail leases are specifically the storefront. We don't give them a whole legal description. We just make reference to the storefront. And that's enough with the street address and the storefront. The beginning and ending dates and length of term are important in a lease. This is a legal document. It has to have a specific beginning and ending date. Length of term, typically you don't have to say this is a 5-year lease and it begins and ends on, but typically it'll say that language. It doesn't have to. As long as it has a beginning and ending date, you can figure out the length of term. But commonly they try to write it so it's easy to understand. Courts do not favor leases of unlimited duration. We used to have more than 99-year leases. Now we just have a 99-year lease. So in Ohio, we have a club land over in Newtown. It's the Huntington Club. Nobody owns the land under their house. They all own their houses, but they don't own the land because they have a 99-year lease. My husband did some work over there years ago. Some friends of ours lived there, and he kept looking at me. Why would somebody want to live here? It's a 99-year lease. I said, they don't care. They want to live in this little Huntington Club. It was an old literally hunting club. And they took the small little shacks and made them gorgeous. They're $400,000 and $500,000 homes today in this little place in the edge of Newtown. And you got to go drive by quite a few roads, and it's far back off the land. It is near. It's near one of the utility towers. Yeah. But they're 99-year leases. Why would you want to live there? Because you want to live in that environment. But you can still get a mortgage on a 99-year lease. You just don't own the land. You own the structure. Hawaii is not land ownership the way the rest of the United States is. A lot of that is leased land. So it also has this 99-year lease. So essential elements of the lease. The compensation paid by the lessee for the possession of the lease premises. You have to state the rent. Rent is stated differently in different parts of the country. In Ohio, we talk about rent for commercial industrial buildings, rent per square foot annually. When I go to Phoenix and I go to California, I get rent per square foot per month. So it's done differently depending upon where it is. But it's very specifically stated. In apartments, it's very specifically X amount per month. It's normally money, but it could take the form of the value of a percentage of crops harvested from the land or relief for the lesser of an obligation owed to the lessee. So you might be leasing a place in return for your sweat equity to remodel it for somebody. So it might be rather than money, it might be the amount of remodeling project you get done. So that can be other than just cash, what you're thinking about. I've done a lot of crop leases, and very often the crop leases might say it's a percentage of the crop brought in that year, rather than a specific dollar amount for the acreage. Again, it depends upon how it's worded, and you've got to look at it. How much, when, and where the rent is to be paid. Very important part of the lease. How much is it, and where is it going to be paid? Our commercial leases say that it's going to be paid to XYZ when you write the lease. It's subject to being changed with landlord's notification. Because the landlord could sell the lease, or they might change where the lockbox is, or whatever. There's a lot of different things that could happen there. Legal use of the premises. When not indicated, the lessee can make any legal use of the land. Courts have old limitations designated in a lease. Okay, so when you lease an apartment, what do you assume the lease is going to be for? To live there. It's going to be your family living in the apartment. And most of them say it's not for any illegal use, which means you can't use it as a brothel or anything like that. They'll say that. in the storefronts that I lease, when I lease a beauty salon, I don't say that it'll be used as a beauty salon all the time. Sometimes I do. But other times what we'll do is we'll say it is used as a beauty salon and not any of these restrictions. Because the beauty salon may change over time, but we have lots of restrictions in our leases. If I have VW3, you can't have their competitor. Michael's there, you can't have their competitor. A lot of my leases say they can't be used for funeral homes. I don't know why. I married somebody. I mean, my son married into that family. I don't know what's wrong with funeral homes. No, but they don't want funeral homes in their shopping centers. It's not what they want. So a lot of my shopping centers have restrictions, and they say you can't use it, or these are protected uses. And the courts uphold those limitations. I've got 7 pages of restrictions in every one of my leases.
Is this still essential?
It has to say, if you don't indicate what it can be used for, then it can be any legal use of the land. Otherwise, you have to indicate. That is its requirement, but if you don't, then it can be any use you want it to be, as long as it's legal. Right of possession. All jurisdictions, the right of possession implicitly resides in the tenant. No one has possessory rights inconsistent with those granted to the tenant, so we're giving the tenant possession. I actually have to do paperwork to say this is when your lease commences. We might give you possession one date, but we give you a lease commencement another date. Because in my commercial leases, they have time to build. We don't start rent until they've opened for business typically. Sometimes we start rent the day we turn premises over to them, but other times it's until they open for business. So it depends upon the lease. But possessory rights is to the tenant. And we'll talk about assignments and subletting here. Recording the lease. Permitted in most states because a lease is a conveyance of an interest in land. Most of my commercial leases say the leases won't be recorded. However, if I'm going to be a tenant, I'm going to go into a space, and I'm going to go in for 10 years or 5 years, and I'm going to put a lot of money as the tenant into remodeling my space for my use, I want to record my lease because I want to tell everybody, mortgage companies, the public, and anybody involved, that I have a leasehold interest in that space. So I'm going to make sure I get to record my lease. So read the leases. Commercial leases very often say they won't be recorded, but again, if you're putting money into it, you may say it's going to be recorded. More likely record leases of 3 years or more. Again, it depends on what the verbiage of the lease is. Types of commercial leases. Don't get caught up in this. It gets confusing. Understand there are different types of leases for different types of properties. A gross lease is a lease in which flat or fixed amount of rent is paid by the tenant. Gross leases are very often office buildings, are gross leases. Net lease, contrasted with a gross, is a type of lease in which the tenant agrees to pay taxes, insurance, repairs, and other operating expenses on the premises, usually on a pro rata basis if multiple tenants are involved. My shopping centers are net leases. We charge back the tenants for all the operating costs. They pay their pro rata share of the operating costs. A true net lease would be an industrial building, where the industrial building is built for the tenant, but they basically act like they own the building. They have to maintain the building, take care of the building, take care of the land, and do everything. Walgreens is another triple net lease, where Walgreens does everything on that corner lot. They do all the landscaping, they pay all the insurance, the taxes, and everything. That's considered a triple net lease. Ground lease, a specialized type of net lease where the lesser leased piece of land, I'm getting ahead of myself, vacant land to the lessee, usually with stipulations lessee at his or own expense will construct the building. McDonald's did a lot of ground leases where McDonald's pays lease on the land, but they build their own building. Not uncommon. Percentage leases. Lease whose rental is based in part on gross sales made by the tenant on the premises. Percentage leases for retail were very common, and it was the only place where we did percentage leases. But today I can tell you in all my leases that I only have a small percentage of my leases that are actually percentage leases. We still collect sales data from our tenants because we want to know how they're doing, but we're not getting percentage rent. We don't do a lot of percentage rents. Yeah.
Could it be because you're losing tenants since people are renting storefront? I mean, stores aren't. Is that affecting it?
No. It's just not as common because we've come to the point where we want to make sure the base rents are paid, they pay their common area costs, and if they get good sales, great, that's all. It used to be if the tenant gets great sales, as a landlord, I want part of it, and that's why I do percentage lease. Because if you did great sales as a landlord, I get rewarded for my efforts for making it a great place to be. Kenwood Town Center. Think about that mall. It's one of the GGP's best performing malls. Of all the malls they own, Kenwood Town Center is one of their best performing malls. They don't do percentage leases anymore. They got tired of collecting all the paperwork and chasing after the money. They still collect sales data, but they're not going back after that stuff. They just a flat lease rate. They pay a flat lease rate, and their share of all the costs. Think of what it costs to operate that shopping center. So you might be paying $50 per square foot for the lease, but you also might be paying $30 a square foot for the operating costs because it's an expensive place to maintain.
Do you think everybody's fee is the same regardless of how like a store is?
No. No, she asked if everybody's fee is the same regardless of how steep the store is. When tenants and landlords negotiate percentage leases, everybody's playing on an even playing field. The landlords know what sales should be. The tenants know what their sales should be. They actually share information. International Council of Shopping Centers produces books where they know what their sales should be. So if you have a store that locates in Kenwood Town Center of a certain caliber, that same store might locate in the Florence Mall. It's different caliber, different percentage sales expected from that store where that's at. So that's how they come about how they negotiate percentage rent. So they know what they're dealing with. But again, a lot of us just don't deal with it anymore because it's just not, it's not where we're going. It's you get so tied up in trying to negotiate that. Now, Marshall's is my tenant up in Huber Heights. We got a bonus check for $60,000 this year because they did great sales. It's the only lease I know up there that has percentage rent. And we were surprised. Hey, that was a nice little check. Because they also have to turn over their sales data and they're obligated, it's an old lease, they're obligated to do it. Okay, index leases, the tenant's leases are tied to a particular index. I don't see this as often. Used to when I started out in business, everything was tied to the consumer price index. Whatever the consumer price index did, when it went up, the tenant's leases went up. This is office, industrial, commercial, everything. Consumer price index is not a good indicator of what true costs are for landlords. It's a great indicator for us as people living in society. The consumer price index tells us how inflation is doing. As a landlord, it doesn't take into account the utility costs and the real estate taxes. Those are the two biggest costs of running properties. So we don't really, the CPI isn't really favored. We'd rather the tenants pay their direct share of things. Or index, we may say that the rent goes up 10 cents every year, or it goes up a percentage every year. Okay, I have old leases in North Park because common area. We have tenants that are on out parcels. They're not our tenants. They're on somebody else's, but they have to cross our driveway to get in. These are leases that started out in 1994. They started out at $100 a month. Every 5 years, they increased by 15%. So I've had to go back in and do all the math from 94 to 99, and I keep doing this 15%, 15%, 15%. So these tenants that started out at $100 in 1994 are now paying $174 a month. It's not a lot of money, but that's what they're paying for the access, the right to go across our driveways, because we have to maintain the driveways. So that's an index lease. Every 5 years, it goes up 15%. So that's another thing we talk about, a stepped or index lease. Lease renewal. Depending upon the type of leasehold, the lease will terminate on its own or appropriate notice by either party. A renewal is considered a new lease, and you can also do a renewal by holding over. How many of you rent an apartment now? Just about everybody's renting an apartment. And when you rent an apartment, you typically rent the apartment for a year. And when the apartment expires, what happens at the end of the year? You sign a lease or you leave. What else can happen? You hold over and you become a month-to-month tenant. Okay, so when you hold over and you become a month-to-month tenant, what happens to your rent? It probably goes up. Are you guaranteed that rent for the remainder of the year? No. That's why they want you to sign a lease so you can guarantee your rent. That's the sales pressure. But that's also the obligation. They're not obligated to hold your rent when you're a month-to-month tenant. What else happens when you're a month-to-month tenant? You can get kicked out with 30 days notice, or you can tell them you want to leave in 30 days. It's either way. But yes, you can get kicked out. So that's another thing. When you're a month-to-month tenant, it's not a permanency. You have no thought about, oh, I'm going to be here for a year. There's no guarantee every month. So you want to, and the same thing happens in commercial leases. Month-to-month holdover. I've had tenants that were month-to-month holders for 30 years. I've also had tenants month-to-month holdovers, and we want them to stay a month-to-month because we're not sure we want them to be here. And that gives us flexibility as a landlord to get rid of them when we don't want them. It goes both ways. So month-to-month is typically 30 days. In Ohio, it's a 30-day period. In other states, a month-to-month might be 60 days. It depends upon the state you're in, how they do that. Lease renewal, let's see. Next thing. That's it. That's it. I'm done. All right, any questions about leases? Again, there are all kinds of leases. Just know if you're going to go into commercial real estate and you're going to be an agent or broker for commercial side, you'll get really familiar with it. If you're going to stay a residential agent, you don't really need to know a lot about leases other than they exist. That's about the extent of it.